Welcome to Sidebar, Bracewell's podcast devoted to government enforcement and investigations, corporate compliance, and white-collar criminal defense. I'm Matthew Nielsen.
And I'm Seth DuCharme.
And we are your host and both partners at Bracewell LLP, where we represent companies, boards of directors, and individuals in all manners of litigation, investigation, and enforcement actions. Today, we have two of our outstanding colleagues to talk about data privacy. What is it? How the law is developing, and what companies should be doing to avoid common pitfalls. Joining us today are Lucy Porter and Brittney Justice, who are part of Bracewell's data security and private practice. Lucy is in our technology group and assists clients with the legal aspects of structuring and designing business processes and information technology systems, including helping clients tailor data privacy solutions to work across their business functions. Brittney is in the firm's trial section and advises clients in privacy litigation, compliance, and government investigations relating to data security and privacy matters. Brittney is also a certified information privacy professional by the International Association of Privacy Professionals. Lucy, Brittney, welcome to Sidebar.
Thanks for having us.
Thanks, guys.
I think this is the first time we've had two guests. So this is such an important topic. We had to have both of you here.
We had to have both of us.
No, but you guys provide, kind of different aspects and different views of data privacy that we'll get into. But I guess let's just step back here a second and say, okay, what is data privacy? Lucy, you want to kind of tell us what it actually is?
Yeah, absolutely. So when we say data privacy, we are, of course, talking about data privacy laws, right? The set of laws and regulations governing the collection and use of your personal information. And the rights that you as an individual may have with respect to that information. So they can be generally applicable, which we typically refer to as comprehensive data laws, or they can be specific to an industry like HIPAA or a type of data, think like, your financial data, or a specific person like children's privacy. They can vary. They can be broad. They can include consumer data or employee data, or they can be narrow, just consumers. And of course, even within the laws that we're talking about, the terms are inconsistent, right? You might see PII, you might see personal data, you might see personal information. Depending on the definition, they all sort of mean the same thing. It is related to data security, but different. So data security is securing data, protection of data, but data privacy is really about data use. So yeah, and of course, if we use a term today that you guys aren't familiar with, or you think your listeners might not be familiar with, don't hesitate to ask us. We, of course, live in this and forget that, these terms are not part of everybody's daily lexicon.
Well, they will be after today, Lucy.
Did you use a plural with listeners? So, Brittney, why does this matter? I mean, besides the obvious, right? Everybody wants their data, their personal information to be private. But, from a legal aspect, why does all this matter?
Yeah, I would say for companies, this stuff matters because of the growing financial and legal risks associated with poor data privacy practices within companies. Threats are growing increasingly sophisticated and pervasive, especially in the world we're living in now. And consumers and regulators are calling for more aggressive action from our regulators and from courts as well. And we're seeing that being unprepared comes with a pretty hefty price tag. So, for example, in 2019, Facebook was fined $5 billion by the FTC for privacy violations, which I think was one of the highest fines we've seen to date. So headline grabbing stories of actions by the FTC, state regulators, and consumer advocates have really demonstrated that a company's reputation and perhaps its economic health may depend in large measure whether the company is following best practices when it comes to data privacy protection and cybersecurity. Because the stakes are so high and awareness of these issues is growing, especially in the media, the way companies handle data privacy and their cybersecurity internally can really become a point of differentiation and even a source of competitive business advantage if they do this stuff right.
Yeah, I'm just curious, when you said, Lucy, I think you said PII, and Brittney, you've been talking about, data security. PII, it sort of trips some wires when we think about protection against breach and the targets of ransomware. Do you see a substantial overlap with how corporations should be thinking about, protecting valuable information from cyber attack, and at the same time, trying to worry about what punishment or consequences they could face from regulators if the fruits of that attack are somehow also governed by these data privacy laws. It seems to me like when you talked about PII at the beginning, Lucy, it made me think, Matthew and I have had a number of conversations recently about, trying to issue spot in the cybersecurity world and what's at stake when an outsider, conducts a breach or gets control of some information, through a ransomware attack. And I'm just wondering what you think about, if a corporation is thinking about both cybersecurity and data privacy, does this need to be a Venn diagram, or can you look at those two issues in isolation?
I see what you're saying. Okay. No, I think they are a Venn diagram, right? I think that a component of every data privacy law is going to be your cybersecurity profile, right? What are you doing to protect your data? And almost every data privacy law that I'm aware of, they hedge, right? They just say using standard best practices, essentially technical and organizational measures. But if you don't have good cybersecurity practices, that's the first thing. So in the event you have a PII breach, the first thing they're going to look at is, were you protecting the data? And so protecting all of your data should be the goal. It's just that if you lose your competitive data, right, your company data, that is a risk, or that is a hit hugely. If you lose your PII to an attack, you also might face a fine from a regulator, but you should be protecting all of it together.
So really two or more ways to get hit, it sounds like, from the same event.
I think so.
So, Brittney, I can't only imagine that the U.S. has a very comprehensive, uniform approach to governing data privacy, right?
Well, if you hear me laughing, it's because every time Lucy and I talk to a client about this stuff, the first thing we say is, this is a complete nightmare, and we're going to help, and we can handle this. But it really is, all jokes aside, it really is a nightmare for companies operating in the U.S. today to navigate the patchwork system of federal and state laws and regulations that a lot of times overlap, dovetail, and even contradict each other. And so, Seth, you were just talking about financial data, and Lucy was talking about PII. There are different laws governing breaches of financial data versus PII. And so a lot of times, you do have to call your privacy lawyers, you have to call your cybersecurity attorneys when this stuff happens, because it really depends on what type of data you're talking about when a breach happens. And so back to what you were asking, Matthew, no, the US does not have a central federal data privacy law like the EU's GDPR. Instead, there's several industry-specific federal privacy laws and regulations, as well as this new generation of consumer-oriented privacy laws coming from the states. And actually, Lucy and I were just talking, Utah last night, the governor signed their new consumer privacy law. And so that makes, I think, now 4 states across the United States that have comprehensive data privacy laws in place. And this stuff is happening overnight, you know?
9%. Sweet.
Yeah, it is happening really quickly. I opened LinkedIn today, and that's how I was notified about it. We knew that it had been passed in the legislature, but the point is that this stuff is happening really quickly. It's gaining a lot of traction across state legislatures across the U.S., and that's kind of a broad picture of it all, and all the moving parts, and really it kind of explains and shows why it's so difficult right now for companies, especially operating in different states, to be compliant with all these different privacy laws.
Well, and just to be clear, we're really talking today about kind of non-healthcare data privacy and security, right? Because, that's a field in of itself. We have colleagues here at the firm who, spend a significant amount of their time on that. And there are, of course, HIPAA. I think most people know HIPAA, and of course, all the jokes about asking various athletes, whether they were vaccinated and whether that was a HIPAA violation.
This is HIPAA.
It's not. But yes, there is a comprehensive federal law and scheme on protection of personal and private health information. Right. But really, we're talking today about, kind of outside the healthcare context, right?
We're also not really talking about financial data, right? Financial data is governed by Graham-Leach-Bliley. So, and a lot of these state laws have carved that out also.
Yeah, that's a really good point. So, I mean, we've tackled it. We've just tackled it kind of in those two contexts. But it sounds like, with the increasing amount of data breaches and, people getting notifications that their information has been compromised. And really, these laws, I think, are more focused on just consumer kind of retail information, right? The ones at least in the U.S.
Well, that's actually something Lucy and I were planning on talking to you about. I mean, a lot of this stuff also has to do with employee information and sensitive employee information that companies have. And so I think one thing Lucy and I deal with when we talk to clients about this type of stuff and try to stress the importance of data privacy is, well, we're not consumer facing. We don't have customers. We don't have customers in the traditional sense. Well, a lot of states are passing laws or embedded in their consumer data privacy laws provisions that discuss protecting employee data. And actually, I was looking at a lawsuit the other day a couple of lawsuits that are being filed in Illinois because they passed a biometric privacy law, which basically states that companies have to give or have to obtain consent from employees before collecting biometric data. Well, these are employees who are using their fingerprints to clock in every single day. Huh. And there's tons of lawsuits being filed by employees against their employers. And it's catching a lot of employers off guard because these are very standard business operations, clocking into work. And so when we talk to clients, sometimes we'll have to tell them, look, these are very basic business operations that can implicate these pretty complicated and serious privacy laws, again, that are being passed, every single day. And sometimes there's not a lot of news around it. And so companies don't know that these laws exist. And so it really can be as basic as employees clocking in, so it does go beyond, I think, the consumer aspect of it.
And, you joke that we're only at 9% of states, but in the last year's legislative sessions, we had over 20 states submit some type of comprehensive privacy bill. So, most of them didn't make it out of committee, but this is happening in every state. Legislatures are considering this. So next year we could be double or triple where we are.
I mean, was there any, it may be hard to figure out given where the proposed legislation was, but was there any kind of common themes on what the impediments were to moving these laws forward in state? Is it just a desire to impose less regulation on businesses, or is it just too complex to figure out what exactly are we going to regulate here?
Suspect the former. I suspect the former, but I did not, I'll just say I did not read into why they never really made it out of committee.
Well, we're gonna X you off from the rest of this conversation.
Brittany, you have
I can talk about that a little. I've looked into this a bit, and a lot of states, when they do draft their consumer or when they introduce these consumer privacy laws, they are mimicking the California Consumer Privacy Act, which is the kind of landmark consumer privacy law in the United States. And the CCPA is pretty hefty. It imposes a lot of obligations on companies. And another thing is that the California AG and a couple of others are the ones who draft these rules that the companies have to abide by. And I don't know if you guys have seen in the news, but it's been a complete mess with the California AG and the various lawmakers trying to draft these rules for companies. They're passing these deadlines that these rules were supposed to be drafted by. Companies don't know what rules to follow. So I think a part of this is, trying to mimic California and kind of watching California and how the CCPA is playing out. And it's not going, I think, as smoothly as everyone thought it would. And so I do think that that's part of the reason these laws might not be gaining as much traction in various state legislatures, especially ones that aren't heavily tech focused like California is.
So, Brittney, you mentioned earlier, and maybe Lucy, I know you deal a lot with this, but the GDPR, what is it, and how does it differentiate between what we have here in the United States?
Yeah, so the GDPR, the General Data Protection Regulation, is the EU's comprehensive data privacy law, and it really is. Became effective in 2018, so we're going on almost 4 years of GDPR implementation, and it regulates everyone doing business in the EU. It is not industry or jurisdiction specific. It covers everybody, employees, consumers, the business-to-business relationship. It has special provisions for minors. And most importantly, it allows for individual member states to make narrower restrictions and to form their own opinions about the activities of either folks in their jurisdictions or the interpretation of the provisions. Why it's really important is because of its extraterritorial applicability. So that is why it's driving sort of international privacy. Even if you don't have an office in the EU, you may be subject to the GDPR if you are selling to residents in the EU. And it's a very fine line to slice what constitutes marketing or selling to EU residents. But because of that, it really is sort of a worldwide implementation. And, everybody knows the GDPR, everybody talks about the GDPR, but there are over 90 non-EU countries actually at this point that have passed some kind of comprehensive privacy law. Even China has passed a comprehensive privacy law that, although is still being worked out, some folks consider to be stricter than GDPR. So it's not just GDPR internationally, and a lot of those international laws are mirror or borrow concepts from the GDPR, but because that was the first, it's really driving international privacy. And it's impacting what we do here too. Last summer, you may recall, I think it was Schrems 2, the case where they ruled against the Privacy Shield, put forth new standard contractual clauses. In order for businesses who do have operations in the EU to transfer data back to the US, you've got to implement one of those new transfer mechanisms because the Privacy Shield is no longer valid.
Yeah, we see in doing internal investigations internationally, you do have to be careful to make sure you understand what laws are implicated because, here in the U.S., generally speaking, if we're doing an internal investigation, there really aren't a whole lot of privacy concerns that we have. We go and we pull emails and we pull information from computers and even company owned devices like cell phones. But if you're doing an investigation outside the U.S., what is just assumed to be in general practice here in the U.S., you can start getting into a lot of issues there, right? Because in many countries, you do not have a right to go look at employee emails.
Yeah,
right.
Even though they are on your server and you're the one providing the email, the company email, you don't have a right to go review that without, for instance, a subpoena.
Yeah. And look, there's a real tension there, right, Matthew, with you're doing this internal, presumably for a couple of different reasons. First, so that the company can get an understanding of what's happening inside, but ultimately so that you can meet the expectations of regulators or investigators or enforcers and put your best foot forward with respect to cooperation credit or just establishing yourself, as a good corporate citizen. And so I'd be very curious to hear from, Lucy and Brittney, what's a corporation to do, or at least how do they issue spot when there's an internal going on? It implicates, let's say, business in the Middle East, business in Europe. There's a concern, that the U.S. government may be at the door and is going to expect, a level of cooperation and disclosure and may not be as sympathetic to some of the privacy concerns of the other jurisdictions. Have you had to navigate or help clients navigate situations like that?
Yeah, we have. unfortunately, if the U.S. regulators are knocking at your door and you don't have the program in place that gives you the right to access those emails, there may be, or that data, I should say, there may be limited things you can do in that moment. So the key is, unfortunately, right, the key is an ounce of prevention is worth a pound of cure, right? If you have employees in a jurisdiction with a comprehensive privacy law, then you need to begin at the beginning, putting in place the right level of notice, the right level of consent, the right level of program details, I guess I'll say, that would enable you to access the data that you need without having to even notify the individual employees. Once the government is calling, you may be limited to asking for it, or hoping that the folks managing that subsidiary or that partner in that foreign jurisdiction can share that with you.
Companies caught between a rock and a hard place, right? Like, you've got this international footprint. Compliance is something that you do, but you're not in the business of compliance, right? So you've got, say, offices in Saudi Arabia, office in Germany, office in France, and, New York, Houston, and DC. U.S. Regulators may have very high expectations, right, of what you're going to produce and when you're going to produce it, and I could imagine, not a very warm response from your colleagues, across the Atlantic when you make this request for voluminous data to try to satisfy those inquiries. I can really imagine how this could create some real tension within the corporation to try to meet all these expectations.
I think you're correct. And I think it when we talk with companies who say, okay, I need to implement a privacy program, one of the things we talk to them about is, well, what's your risk profile? And we talk to them about the risks of not putting a system in place, and this risk of U.S. regulators coming knocking and saying, we want all this data from this jurisdiction, that is a real risk. And is that a risk you're willing to take on? I mean, we think about it in the context, everyone's ready to think about the risk of, I'm going to get fined because I'm not compliant if, say, France, in your example, finds out. But it's not just the French regulators, to your point. So we talk them through that.
Right. And is it even legal? Right. Which is the ultimate question presented to the lawyers. If you're storing your data, and I know in the current world of, cloud-based storage with server fields, all over the planet, where is this data? Right. Whose laws, control how that data can move? Yeah. And I can think of at least, one notable occasion where a company sort of shrugged at U.S. investigators and said, hey, sorry, that data is not here in the United States. It's stored internationally, and, we can't get it pursuant to foreign law. So that, you obviously want to meet expectations and, from all sides, internally and externally. But as you're talking, I can really imagine some scenarios that would be less than satisfying for all the stakeholders.
Actually, to your point, there's actually been a couple of federal courts in the United States who have dealt with that specific issue where, opposing parties are asking for documents to be produced. The other party says, well, sorry, my servers are in Europe. I can't turn over this data. It's subject to GDPR. And the court has said multiple times, we don't care. Produce the documents. We're not subject to GDPR. And so it does create a lot of issues for companies who are stuck in this position of, not turning over documents and getting in trouble with the court versus violating the GDPR, which could be extremely costly. And so, it's a really complicated situation to be in. And that's why, it's really important to know where your data's at, know what country it's in, know what laws you're subject to, because it could create a lot of problems down the line.
I'm drawing a blank, but there was this 10 years ago, I'm sure, who knows what's happened to it. There was this abandoned platform in the sea off of the coast of England. You probably know what I'm talking about, Seth. And they literally, this guy had created a kingdom, and he was, of course, the king. But it was essentially a server farm for bad guys. And so I'm going to go with he didn't adopt the GDPR or UK regulations in his, kingdom that he had created.
Right. All my data is a barge in the East River. That's where I keep all my data.
Mine's on a floppy disk. I mean, I don't have much data. So what are some of the common pitfalls that you guys are seeing when you're talking to companies about these issues?
I think one of the most common things we see with various companies is not organizing data correctly. And that can be not knowing what data you have, not knowing where it's located, not knowing who has access to it. It can be a ton of different things. And it can create a lot of problems down the line for companies. And the solution to this is data mapping. So data mapping is an essential component of the GDPR. It's considered to be the foundational step for the fulfillment of all legal requirements of the regulation. And it basically entails identifying, understanding, and plotting what information an organization has, how the data flows through the organization, who has access to the data, and where it's stored. And one area that this proves to be very useful is when an organization receives a personal data request. So the GDPR and the California Consumer Privacy Act give consumers the right to request all of their personal data from a company. And the timeline and the turnaround for turning over this personal data to consumers is pretty quick. And if you don't know what data you have or where that data is located, how can you possibly, within the required timeline, turn this data over to the consumer who's requested it? And so you can see how a company not knowing where their data's at, what data they have, can really be a recipe for disaster in these types of situations and can just create a lot of problems internally.
Yeah. And I mean, Seth, you literally just brought up how data mapping, imagine the US regulators come knocking, oh, we want all this data. And then all of a sudden you're like, well, I don't know where that data is. And then you realize, oh, it's in the EU. Oh, this is not great at all. How are we going to get this data? Well, if you've done a data mapping exercise, then you might know that was already there and move it. You've already pre-moved it, right? Or you might have already put in place the systems that would allow you to have access to that. So not to downplay the requirements for, data subject access requests, but anybody who is collecting large amounts of data of any kind, obviously personal data is where we're focused. We think data mapping is just hugely valuable.
By the way, it's the Principality of Sealand is what I was thinking. And it is off of the coast of England. And it's worth a Google search because there's some absurd stories about His Royal Majesty of the fort system that, shooting 22 caliber guns at people trying to pick them off.
Yeah, it's not where you want to take your kids for a dolphin show. That's to be clear, there have probably been some misdirected tourists. Yeah, look, it's very interesting, this notion of data mapping and the geolocation of electronic data and how credible that really is to the parties that you're trying to convince that while you might be able to pull it up on your desktop in New York, that data really lives in Ireland, or somewhere else. But when you talk about data mapping, I guess in the first instance, at least, you can form an understanding of what is where and how it could be accessed and what regulatory schemes apply. Is that right?
Yeah,
yes.
And that's incredibly important whenever there's a breach because, we've worked with clients before who didn't have proper data mapping procedures in place. And how are you supposed to know who to notify if you don't know what data was breached? And that can be federal regulators, state regulators, affected individuals. And the timeline on notice on these laws, they're 30 days or some of them are 72 hours for federal regulators, depending on what industry you're in. And so if you don't know what data you have, how are you supposed to properly notify any of the people that you have to notify when a breach happens? And in this day and age, federal regulators are not sympathetic to you saying, oh, I didn't know healthcare information was breached. Oh, well, I didn't know we had employee data that was affected here. I mean, they're not sympathetic to these arguments anymore. And it's something that organizations have to take seriously.
No, you're absolutely right. I mean, the government has said in one form or another, the grace period is over, essentially. 10 years ago, you might have gotten sympathy while you're figuring out, how to protect yourself, how to protect your data, and what all these rules mean. But the messaging, from the current administration over the last year, Matthew and I have seen a new announcement, almost on a monthly basis, get ready, here we come. We want, we're announcing new rules and we're going to hold you accountable to those rules. So I think the grace period really is over, and it's a foreseeable, right? The notion that you're not going to have an event that implicates the data privacy rules and the cybersecurity notification requirements, that I think is truly fanciful. I mean, corporations certainly are on notice that they're going to need to be able to timely report and have a command of what happened. And I think that's what I take from your, you banging the drum on data mapping and the programmatic approach to this. The company needs to be able to internally figure out very quickly, what happened, where it was, and what regulations are implicated, because there's certainly going to be the expectation of the government.
Yeah, and government kind of across the board. I mean, not only those agencies that are going to regulate, the breaches and, the theft of personal information, but now we've seen the SEC become, for instance, a lot more active in this. They've been saying for years, we're going to become active. And of course, they've been active with regard to regulated entities like broker dealers and investment advisors. Yeah. But we've seen activity from the SEC on whether your internal controls on reporting are sufficient. In other words, whether you're reporting the risk to the company of these breaches, and specifically, for instance, loss of maybe personal information that you have stored, and the implications to your customers and implications to your business because of that.
Right.
Well, and the other piece that we haven't, I guess, we sort of touched on is data mapping can help you to be more flexible, right? I mean, we've talked a little bit about how this is a changing landscape, right? Literally last night, Utah governor signing their privacy law. Well, if you know where your data is and you know what data you have, as the rules change, as the regulations change, you are going to be much more nimble in responding to those rules and be able to roll out the processes that are required to comply with those rules. And I mean, this is regulation, right? It's expensive. It takes time. So don't wait until 6 months. I mean, the GDPR passed in 2016, and 6 months before it went live, people said, oh, that comes online in 6 months. Right. And there was a mad dash scramble to become compliant. People didn't know what their data was. And so if you start now, it will help in those efforts.
I remember the year of the GDPR symposium. It seemed like there was one every 2 weeks.
Yes.
Because people were trying to figure out what it was going to mean. Maybe it was more than a year.
I mean, obviously, and Lucy, you made a really good point, and it's one that we make over and over again, both, of course, on Sidebar, podcast devoted to government enforcement and compliance, but also with regard to our clients, is that, ultimately compliance is and should be a risk-based approach, right? And so obviously the more sensitive data that, from a data privacy standpoint, the more sensitive data you have, the more compliance you need. We've already talked about, of course, financial firms and healthcare providers and those who deal with that information. That's already regulated, but there's a reason, because that type of information is much more sensitive, and there's a lot more risk associated with that. Although now we're starting to see risk with regard to other types of personal information. But, so getting into the nuances of a compliance program is probably kind of beyond, the time we have today, and obviously we'd be very specific. But let's just talk about a company that is starting up brand new, right? Let's talk through the basics of what companies should be doing, from a basic standpoint of starting to build a compliance program.
Yeah. So after they've called us and gotten us engaged on their team, no, seriously, I think the first step is, you need a multidisciplinary team, right? So you need your legal and your compliance folks involved. You need to have HR involved. You need IT. You've got to have your IT stakeholders involved. And thirdly, marketing. A lot of marketing campaigns are going to use personal data because email addresses are going to be personal data. Huh. So once you've got your multidisciplinary team engaged, then you can more easily implement a concept called privacy by design, right? Which is going to approach new products, new services, new activities by looking at it from a privacy perspective. And that should, if you're doing that from the very beginning, help you to, consider data mapping, consider, updates to your privacy policy, things like that.
And I'll add on to that really quickly is, we're not only talking large companies like Facebook, Uber, PayPal. There are small companies too who have, more limited resources who also need to implement comprehensive privacy programs internally. And whenever Lucy and I talk to clients about that, the first thing we do ask them is how much of your resources are you willing to devote to your privacy compliance? Because another federal regulator here I feel like we don't talk about as much is the FTC, who has really been increasing their enforcement actions over the past decade for companies who engage in unfair and deceptive practices, which has basically been interpreted to mean saying you're doing one thing with regard to privacy and not actually doing it. So we've seen them going after companies who have these privacy policies on their website, and these are startups, these are smaller companies who say, we're not selling your data, but they're actually handing it over to one of their vendors. Well, if you don't disclose that, the FTC can come after you and impose some hefty fines. And so, this is where we as privacy lawyers, we walk a really fine line and have to work really closely with clients to really understand their capabilities when drafting privacy policies and other internal policies to really ensure that the company isn't over-representing or over-promising things that they can't actually commit to internally. And I think that's a really important point to make here.
Yeah, I agree. That's one of the first, introductory questions I always ask when working with a new client is, what is your risk approach to privacy? Or what's your risk profile overall, right? How do you as a company manage regulatory compliance? And if you're starting new, right, of course, that's a conversation you're having about a lot of areas because in some cases, a one-size-fits-all approach might work. You follow California, you're going to do it for everybody. That's just the easiest way. You'll give more protections to people because it's easier to manage. But for others, where they're maybe smaller, or maybe they've got, a patchwork of requirements that require different, employment data has to be handled one way, consumer data another. They may not be able to do that. So they're willing to take on a little bit extra risk by going jurisdiction by jurisdiction. So, defining your team, defining your approach, that's where we start. And you posited this as starting new, but even existing clients who suddenly find themselves in Virginia, in Colorado, in California, and this is the first time, they're having to develop this is where we start.
That's right. Well, this has been a really great discussion on, data privacy. I'm guessing that, this is probably not the last time we're going to talk about it because, this is a developing area. Like you said, the states are starting to regulate this. Of course, that's creating all sorts of interesting challenges, like you just said, Lucy, on businesses that operate in these multiple jurisdictions that don't necessarily align on what their requirements are. So this is really a very developing area and it is one that's going to continue to do so. Look, appreciate you guys' time and your insights and your expertise here and appreciate the discussion.
Well, thank you. We are happy to come back anytime. Maybe we could come back towards the end of the year and talk about what the states have been doing.
Yeah, I think we'll insist on it, actually.
Okay.
Well, thank you for joining Sidebar. You can get Sidebar anywhere that you listen to podcasts, and you also can get it on Bracewell's website. We'll be back soon with another episode. Thank you.